8 and 2023 CR 5264, State of Texas versus Kevin Michael Neuenfeld. Can I have parties announced for the record for the state?
Daniel Escobar, State of Texas.
Defense.
Milton Butler representing Kevin Neuenfeld.
And are you Mr. Neuenfeld?
Yes, Your Honor.
Buckle up for a courtroom roller coaster where two cases collide in one courtroom, and both center around one man, Kevin Michael Neufeld, with 2 felony charges, multiple violations, and a shocking plea to salvage what's left of his probation. This case is about to test the court's patience and yours. The stakes, up to 8 years in prison, twice, and a judge who is clearly done playing games. And just when you think it's over, another defendant steps in with a jaw-dropping story of betrayal, violence, and intoxicated decisions. We're breaking down the law, the logic, and the human drama behind every gasp-worthy moment. Grab your coffee, this is not your average court session.
For the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on July 20th, 2023 for a term of 10 years. Is that you?
Yes, ma'am, Your Honor.
All right. State, in each of the motions, are you proceeding on the same allegation?
Yes.
Any objection to the state reading the allegation once and having your defendant plead true or not true to each of the cause numbers?
No objection.
All right, state.
Violating condition number 4 in Bexar County, Texas. Defendant Kevin Neuenfeld, then and there, failed to report to the supervision officers as directed for the months of March and April 2024 in violation of condition number 4.
How do you plead to that in each of the motions? True or not?
2 words that land people back in court more than anything else. It's didn't report. Kevin missed check-ins in March and April, and this isn't even his first time. Remember, probation isn't just a get-out-of-jail card, it's a contract with strict terms. When the judge hears he's violated the same condition again, that's not just a red flag, that's a siren.
Yes, Your Honor.
And sentence you up to 8 years in the prison and up to a $500 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4 in that cause number?
Yes, Your Honor.
Did you understand by pleading true in the cause number ending in 1478, the court can find it true, grant the motion, and sentence you up to 8 years in the prison and up to a $500 fine?
Yes, ma'am, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4 in that cause number?
Yes, ma'am, Your Honor.
Then in each of the cause number, the court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor. The proposed agreement is a 60-day jail sanction and serve 90 days of jail sentence.
All right. And probation?
Judge, that's what we discussed, but I do defer to the court.
All right. I'm not going to follow this agreement. I'm going to revoke you. He was previously here on January 23rd, 2024 for the same.
Whoa, did you catch that? The judge just overruled the plea agreement. That rarely happens unless the court sees a pattern of disrespect or danger. Kevin had already been warned back in January, and the court gave him extra support from CPS compliance to random drug testing. But now, the same violation. The judge has had enough.
Doesn't want to report.
Your Honor, I think you'd like to address the court on that issue.
All right. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand, state your name for the record.
Kevin Neuenfeld.
All right. What would you like to say?
I wanted to let you know that I had a near death with my mom and family. She ended up getting a tracheotomy. At that point in time, it was March. I did report in February after getting out in January. I reported in March. I reported February, I believe. March was when she went to the hospital. She didn't get out until April. And then right immediately after that, I lost my nephew that I helped raise as a son. He was a month before his 26th birthday. He's just, him and my son are 2 months apart. My son just turned 26 in April as well. And I just kind of going in shock. I didn't relapse or anything. And I did try to get a hold of my probation officer. I was just hoping to get reinstated, and it's the last chance I could have to just follow through with probation and be a success story for it.
All right. The court is going to revoke you in each cause number. Does anyone wish to speak to punishment?
State of recommend 7.
All right, defense.
Now this is where things get real. Kevin opens up about a near-death scare with his mother and the tragic loss of his nephew. You can hear the weight in his voice, and yes, it's heartbreaking. But here's the hard truth. The justice system operates on consistency, not sympathy. Even emotional trauma doesn't erase legal responsibility, especially after prior warnings. What do you think? Should judges consider emotional hardship when someone violates probation? Let us know in the comments.
8, there's an affirmative finding of family violence. There's to be no contact with Deborah, Debra, Marie Neuenfeld, and Pamela Pettis. There's a $500 fine. Time and money will run concurrent. And in the cause number ending in 5264, again, there's an affirmative finding of family violence, no contact with Deborah, Marie Neuenfeld, and Pamela Pettis. And there.
The gavel falls 6 years in prison, concurrent for both cases. That means he'll serve him at the same time, but let's not gloss over this. He's got a family violence finding on both charges, a $500 fine for each, and he's barred from contacting 2 women. That's a legal wall between him and his past, and it's not just about punishment, it's about protection.
The allegations in the motion, not the fact that you were on community supervision. Because in each of these cause numbers, this is a felony conviction and also an affirmative finding of family violence. You're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. Court is calling 2024 CR 007137, State of Texas versus Ryan Roman Valdez. Could I have parties announced for the record for the state?
Stephen
Defense.
Harquist for Mr. Valdez.
And are you Mr. Valdez?
Yes, sir.
Counsel, have you received all of the discovery?
I have, Your Honor.
Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Valdez, did you review the document entitled Application for Community Supervision or Deferred Adjudication with your attorney?
Yes, sir.
Did you understand it and sign it?
Yes, sir.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented? Did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney?
Yes, Your Honor.
Did you understand it and did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of burglary of a habitation
Yes, Your Honor.
with intent to commit assault? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't.
Enter defendant number 2, Ryan Valdez. His charge, burglary of a habitation with intent to assault, serious business, a second-degree felony. But unlike Kevin, Ryan is going for deferred adjudication, meaning if he follows the court's orders, he could avoid a conviction. But this case, it's about to take a wild turn.
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, we've discussed them.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Valdez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state recommends deferred adjudication. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
And did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be your plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea? Did you review the waiver of appeal with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be no contact with the complainant, and that there be restitution to the complainant. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Plead guilty, Your Honor.
State, any evidence? Any objection?
No objections, Your Honor.
State, have you spoken to the complainant?
Yeah.
And they're aware of this agreement?
They will, yes.
All right, thank you. You may be excused. Mr. Valdez, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, we would waive the PSI and
All
ask
right.
the court to follow the state's recommendation, Your Honor.
All right. Mr. Valdez, what is your issue?
My issue, I had gotten cheated on 3 years ago. And during this time, for what I was accused, my burglary of habitation.
Wait a minute, I can't hear you.
I'm
What?
sorry. The allegations that what I'm being charged with, she had said she wanted to be back together. We were still married at the time.
So why are you removing an AC unit from your child's bedroom?
During that I was impaired under alcohol.
Mhm.
And I'm honest about that. And during the whole thing, I could recollect a little bit. What I remember is that I didn't go straight to her bedroom. We had a conversation in the living room. And then that's when I found that there was another man inside her bedroom. And he confronted me and asked who I was. So therefore, that's what I said. I'm her husband. He freaked out and said, I didn't know you were married. So then he said he was leaving and he confronted me. And then that's when we started getting into a fight.
So how did she end up getting beat up?
She started.
Here's where the courtroom tension explodes. Ryan admits to being intoxicated and driving to his estranged wife's home, where he confronts another man and things spiral into violence. The judge, she's visibly disturbed. She calls out the logic. You say you're trying to get back together, but show up drunk. It's a moment of raw accountability and a reminder that actions speak way louder than words.
With her because she wanted to work things out with me.
Mhm.
Yes, ma'am.
And then, so why would you show up at her home intoxicated? That doesn't make sense to me. If you're trying to get back together with somebody.
We were talking and texting during that day, and then out of nowhere, it was just no contact, and it just wasn't normal for her. And she was already accusing me that I was cheating on her and stuff like that.
So I don't understand how that translates into you getting intoxicated and going over to the house.
I was already intoxicated, and I don't know why I went over there.
All right. Well, your relationship with her is over.
Yes, ma'am.
Do y'all have children together?
Yes, we do.
What are their ages?
My son Roman Valdez is 8 years old. My daughter Zoe Valdez is 4 years old.
All right. So you all are going to have to make arrangements. Is your mother?
Those arrangements are in place already.
All
Your
right.
Honor.
So there's to be no contact with her. Do you understand?
Yes, ma'am.
And here's just some side advice from me that I'm sure your attorney will tell you about. even though there's a third party who's going to be doing the custody exchange, it's best if you have a significant other that they're not a part of the custody exchange. That always causes problems. You understand? All right, the court is going to sentence you to 5 years deferred adjudication. Is CPS involved or no?
No, they weren't, Your Honor.
There's
And they're divorced now.
All right. There's an affirmative finding of family violence. There's to be restitution, if any, to the complainant.
Let's pause to unpack Ryan's sentence. He gets 5 years deferred adjudication, but that's not a free pass. He has to prove employment, avoid work with minors, complete anger management, attend 90 sober meetings in 90 days, and undergo a TAP evaluation. And yes, any violation could send him straight to prison for up to 20 years. The court is watching closely.
As a home health care provider or with minors, I'm going to want a TAP evaluation, follow recommendations. That can be out of custody. If they're recommending inpatient treatment, we'll start with intensive outpatient treatment through probation. I'm going to want 90 sober meetings in 90 days, regular reporting by Zoom or in person, regular random UAs, field visits 1 time per month for 3 months. Then at probation's discretion, 100 hours of community service restitution. I'm going to order parenting classes. Once that's complete, community service hours will be deemed satisfied. Probation, is there anything else he needs? Is there anything else you need from the court to be successful? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence. I'm sorry, probation.
Let's recap Kevin Neufeld, 2 violations, 1 emotional plea, and ultimately 6 years behind bars. Ryan Valdez, a second chance with heavy restrictions and the threat of 20 years if he slips. Both cases carry affirmative findings of family violence, a serious mark with long-term legal consequences. These weren't just legal decisions, they were personal wake-up calls. So here's our question. Do you believe in second chances, or should the system crack down harder? Tell us below.
Court, and we'll see what's going on. Do you understand? All right, good luck to you. Thank you.
Thank you, Judge. Yeah, this-